Okay. All right. Welcome, everybody. My name is Karena Nicholls. I'm a partner here at Coutts Lawyers and Conveyancers. I will do that so you know who I am. I specialise in employment law, and particularly that's the subject for today. I also specialise in personal injury law, which factors in things like workers' compensation, sexual harassment, other stop bullying orders, all sorts of things that fit into that space. So I've been doing law for, a while now, as you can see. And I'm really passionate about making sure that we provide information to our local community. So welcome to everybody who's been here before. Our last workshop, we're trying to roll out a few more in relation to making sure everybody's up to date. Welcome to everybody who is online. There's a few people that physically couldn't get here. Technology is a wonderful thing that now you can sort of watch from home and do a recording as well. I believe it's been recorded, so we'll circulate it as well. So if there's any questions that you have, we've got a Q&A at the end. Write them down on your phone or whatever you have, and we can go through those. So I also want to welcome Melissa Care. Melissa Care is sitting at the front here. She's a senior associate here at Coutts Lawyers, specialising in employment law, commercial law and litigation. So all the things that you hate doing, which is litigating, she's probably the lady for you. We also have Belinda. Most of you know who Belinda is. She presented last time as well. She owns HR Focus, which is a human resource HR, I would say a bit of an all-in-one bag, does whatever I needed to do. Also is one of the HR managers for Coutts, so helps us manage our team and also refers work to and from each other in terms of our connection, because a lot of the times HR get to a point where they actually need legal advice and then need to progress it through proceedings. All right, so what we're going to do is we've got a bit of a run sheet here. So we're going to start off a few different topics that we're going to go through. Mel's going to kick it off, so I'll hand it over to Mel. And what's going to happen is we'll go through each of these topics. Any questions you have, we're happy to go through those. It's an information session more than anything else. The goal here is for you to walk away with something rather than just come and have a muffin. That's not the goal. So if you have any questions, please let me know. I'll hand it over to you, Mel.
Hi everyone, and thank you for joining us in the room and online. So for those that joined us last seminar, we did talk about shutdown provisions, and at that time they weren't in place as yet, but they actually are now in place. So this is a bit of a reminder, especially with the upcoming silly season, which is approaching, and a lot of businesses shutting down over that time. So the Fair Work introduced these shutdown provisions to 78 different awards. And that means that these new shutdown provisions require employees to give their employees at least 28 days notice of any shutdown provision. The temporary shutdown provisions obviously impact employees, and what it requires businesses to do is that if you require your employee to take paid annual leave during that temporary shutdown period, then they should have enough paid annual leave in that period of time. And that the employee, if they don't have enough paid annual leave in that period of time, then you need to come up with some sort of arrangement or agreement with them. So in the past, if somebody didn't have enough leave, they would probably just take it unpaid during that period of time, and you could, ask them to do that. However, now under these new shutdown provisions, there basically has to be an agreement. So if there's not enough paid annual leave, then you have to come up with some arrangement, which may include using accrued time off or annual leave in advance if you're willing to pay that, or leave without pay. So basically the new shutdown provisions are putting an obligation on you during the year that if people are asking for leave, to keep in mind these shutdown provisions to ensure that when it comes to those shutdowns, that they will have enough leave, and so that you're not going to be in this situation. So you need to consider what awards impact your business and the obligations to provide that notice in time. Under some of the awards, there is more time that is required for notice. So whilst the minimum is 28 days, there are some awards which require a little bit more, such as the Building Construction General and Site Award, the Joinery Building Trades Award, the Plumbing Fire Sprinklers Award. These require a 2 months minimum notice. So with Christmas coming up, you've really got the next coming days to give that notice to those employees in those specific industries. So it's really important to check your awards, the notice periods required, and give that notice ASAP if you're closing down over the Christmas period. In terms of what it means is that if you've looked at your employees and they don't have enough paid leave, then you will have to try and negotiate something with them, and it could end up in a situation where you may need to pay them in advance. You can't force them to be taking the unpaid leave anymore. So what this means for the business is that, as I said, you should be reviewing your current leave policies, employment contracts, procedures and awards to ensure that you've got the annual shutdown notice periods right, and updating any of your documents for the employees that are impacted by that. You should, during the year, moving forward, particularly when exercising your annual leave requests and reviewing those, that you make sure that your staff will have sufficient leave for those shutdown periods. Discuss with your HR or business partners the future changes to make sure that those notice periods are taken into account, and updating your payroll systems and things like that. As we've said, there's still a fairly early change, so it only came into effect in May. We haven't seen a lot of these cases being tested or anything like that where people have been forced, or there's been no negotiation about the shutdown periods, but we watch this space and see where things go. But just a friendly reminder with Christmas coming up, that take action now. Move on to Belinda.
Thanks, Mel. So there's been some changes with the parental leave. So essentially from 1 July this year, they've extended it to 20 weeks combined between the mum, both partners or both parents. So the former dad and partner payment has been removed, and there's an additional 2 weeks being added to the 18 weeks parental leave. So each parent will be essentially able to take the 2 weeks, depending on which parent wants it, after the birth or adoption of a child. So parents who are single are entitled to claim the full 20 weeks. And the government will, so it's essentially increased from 18 to 20 weeks, and they can share it amongst themselves from March 2024. The federal government has announced that they're going to gradually increase the parental leave payment to 6 months of paid leave by 2026. So yeah, that's a lot. And there's also going to be a cap. So there's an income limit. So there's a family income limit, which is going to be indexed, and it's 350,000 combined family income. So making the whole payment flexible so that eligible employees can claim it in multiple blocks as well until the child turns 2. So it's removing the requirement to return to work to be eligible for the entitlement as well. So previously, to get the paid parental leave, you had to return to your previous employer. That's been removed. So it essentially means you've got more flexibility when it comes to people returning from parental leave, so they can combine maybe coming back after 3 months and maybe coming back 2 days and taking 3 days parental leave if they're a full-time employee. So it gives a bit more flexibility, or people can still take the block 20 weeks and then just have the rest of the time off. So it just adds a bit more flexibility to the parental leave. So what do you need to do as a business? So if you have staff that are eligible for parental leave, you need to register with Services Australia prior to the employee commencing leave. The government will require you to accept the application and confirm their employment. I would suggest you need to do that at least 3 months out, generally speaking, because it can take a bit of time depending on how busy they are. And it can take a bit of time for payments to come through. So you want to make sure you communicate with your employees that they're on top of accessing those things within doing that, because the employee has an obligation to apply, you have an obligation to accept and process that. And you've got to have your portal all set up. It's not just, you've got to have it all set up properly. And the employer is responsible for processing those payments on behalf of the government to the employee, and the employers need to allow that flexibility in returning to work from parental leave. As I said, having that potential to have 3 days paid parental leave and working 2 days a week for that 100 days that they've got, which is essentially your 20 weeks. Respect at work. This is probably a big one. It's essentially been in place for 12 months, but there's been no policing of it. That's starting from November. So the Australian government introduced the Anti-Discrimination and Human Rights Legislation Amendment, Respect at Work Bill, in 2022, which implements 7 of the 55 recommendations from the Human Rights Commission.
So the Respect at Work report. Significantly, the bill imposes a positive duty on employers to take reasonable and proportionate measures to eliminate as far as possible certain discriminatory conduct, including workplace sexual discrimination, harassment and victimisation. So the key there is positive duty. You have to proactively ensure you're making sure that in your workplace there's no sexual discrimination, no harassment and no victimisation. So the days of just having a policy and hoping for the best is gone. You actually have to educate, you have to train, and you have to take a proactive approach in your business to ensuring that sexual harassment doesn't occur. So sexual harassment is a human rights issue and a workplace hazard, and it is known to cause psychological and physical harm. So there are various laws across Australia in both state and federal and territory and international levels that relate to sexual harassment, such as the Sex Discrimination Act, the Fair Work Act, state and territory anti-discrimination, EEO and human rights laws, state and federal WHS and compensation laws, and also criminal law. So sexual harassment is against the law in the workplace. So sexual harassment is against the law if it occurs between individuals who have a particular workplace relationship, during work or in connection with work. So in connection with work is a really important thing here. Workplace relationships can include prospective employer, so in the recruitment process, if someone's doing interviewing, employees and their colleagues, PCBUs and workers, so PCBUs, persons conducting a business or undertaking, workers and prospective workers. A worker is anyone who carries out work for the employer, so that could include your contractors. So sexual harassment is defined in Australian law as any unwelcome sexual behaviour that a reasonable person could anticipate may make another person feel offended, humiliated or intimidated in that situation. I like to refer to this as the pub test. If at the pub we thought it was wrong, then it's probably wrong. So if a reasonable person thinks that conduct is unacceptable or wrong, then it's more than likely could be seen as sexual harassment. There's three elements of sexual harassment. There's the conduct that is of a sexual nature, conduct that is not welcome, and conduct which is offensive, humiliates or intimidates. So that's what underlines those the elements of sexual harassment. So what does sexual harassment look like? This is a sheet from the Respect at Work. I would strongly suggest making sure you have a copy of this, have it displayed in your lunchrooms, provide it to your employees in their induction. It covers it fairly succinctly what is sexual harassment. So it's inappropriate physical conduct, it's intrusive questions about a person's private life or their physical appearance, sharing or threatening to share intimate images, video without consent, images or videos that are sexually suggestive or that constitute a sexual advance, unwelcome touching, hugging, cornering or kissing. So I think the hugging one, I think as humans we tend to sometimes just do that. We need to be really careful of that. Repeated or inappropriate invitations to go out on dates. I've had a number of these come up in the last 12 months, particularly where I've got employees that have young staff working for them. And we've had to handle those sort of situations. So if they repeatedly ask, it's repeated. So if somebody asks once and they say no and they don't do it again, that's not. But if they continually say, hey, when are you going to come out on a date with me? When, I'm sick of you saying no, that would be considered sexual harassment. Sexually suggestive comments or jokes that offend or intimidate, requests or pressures for sex or sexual acts, sexually explicit gifs, images, videos, cartoons, drawings, etc., actual or attempted rape or sexual assault, being followed or watched inappropriately or someone loitering inappropriately, either in person or via technology, sexually explicit comments made in person, in writing or indecent messages, so your social media, text messages, your WhatsApps, your Snapchats, all the other different forms that it can take, sexual gestures, indecent exposure or inappropriate displays of the body, technology facilitated unwelcome conduct of a sexual nature, so potentially by virtual meetings, inappropriate staring or leering, repeated or inappropriate advances on email or other online social technologies. So there's a lot of things that we need to think about, and there's a lot of education that we need to provide to both employees and managers and supervisors within your teams about what sexual harassment looks like, because I see that this is going to be the next uptick in terms of claims. Bullying's probably been the one that we've seen in the last couple of years. This one will start to flow through as well. So I'll give you an example I had recently where I had a particular person was at an event which was outside of work hours. He had been chatting to a colleague. They'd been talking. They'd arranged to go out on a date verbally, so it was all verbal. They were at the pub, which was sort of a work-related event. It wasn't a sanctioned work event, like the work weren't paying for it, but they were all there because they all worked together. He inadvertently, she was leaving, he turned around and tapped her on the back, sort of on the back here, and she said, "Don't do that to me, don't ever touch me again, blah, blah, blah." On the Monday, he got a show cause letter from his HR department, and I said to him, "They're going to fire you. That's sexual harassment." I said, and it's a dismissible offence. And I said, "Do you have any evidence to say that all this other stuff?" He goes, "No, it's all verbal." I said, "Well, do you want to get fired or do you want to resign?" He resigned. Because the letter was very clear. Like, I've written plenty of show cause letters over the year, and I'm like, yep, if I'd written that letter, I'm firing you. So, and it was, that in itself is deemed, under these rules, would be considered to be sexual harassment. So it's real, and as a business, as business owners, as people managing people in business, you have a positive duty to make sure that doesn't occur in connection to work. That was in connection to work. So generally speaking, most of the sexual harassment things I've come across in my 20-something years, 25 years plus as HR, has usually come as a result as Christmas parties, work events. That's where everybody gets a little bit loose and gets a little bit, bit of alcohol added in, and Monday, HR departments are busy after those events. So I think it's really important that if you're having events like that, you need to reiterate that it's a work event. Appropriate conduct is required, that they, it can lead to them potentially losing their jobs if they do these sorts of things. So they need to be really, really clear about it. And particularly your managers, they need to understand that as well. So what do you need to do? So PCBUs are required to actively prevent workplace sexual harassment and discrimination rather than just respond to it. So up until now, we've sort of been a reactive response to sexual harassment. We didn't really do anything apart from have a policy. Maybe you've done a bit of training here and there, but we've got a policy, we induct, that's about it. That's all we really were required to do. Now we have to actively prevent it from occurring in the workplace. So positive duty imposes that legal obligations on employers to proactively and meaningful action to prevent workplace sexual harassment, discrimination and sex-based harassment. So recommendations that we're recommending is review your company policies and ensure they have a clear sexual harassment policy. I'll probably have it as a separate policy, not included in a policy. Train your managers on how to identify and respond to sexual harassment complaints and monitor acceptable behaviour in the workplace. So if you're seeing things in the workplace that are bordering on, moving into that space, you need to pull it up, you need to stop it. Train all staff on what is sexual harassment, noting that this should be ongoing, not a once-off. So you can't just do it when they start or, and let's forget about it. You have to be ongoing. And it needs to be in different formats, not just the same. So it could be online, team building, team meetings, toolbox meetings, video training, a whole range of different things, and making sure that people are aware of what it is. At induction, provide new staff with policies, training on sexual harassment. Ensure we have a clear grievance procedure so people know what to do if they have experienced sexual harassment in the workplace. Lead by example, obviously, and manage the culture within your organisation so that people know that it's not acceptable behaviour. And manage that risk in your business. The little chart there is essentially the respect at work model. So they're wanting, strong leadership, risk assessments and transparency is important. Culture, knowledge, providing that knowledge to individuals, providing support, reporting, so keeping records of those things that are happening if it does happen in your workplace, and then measuring that, having a good response and prevention. So paid family and domestic violence leave. So employees in all businesses now have access to 10 days of paid family and domestic violence leave. So employees must be experiencing family and domestic violence to be eligible to take the paid family and domestic violence leave. An employee's paid leave entitlement is available in full immediately, so it doesn't accrue. They get the 10 days straight away, and it resets on their work anniversary. So if somebody starts with you today, they're automatically entitled to the 10 days, and it resets on their anniversary. Doesn't accumulate from year to year though, so they don't, just not like sick leave, it doesn't accumulate. An employer can ask their employee for evidence that shows that the employee took the leave to deal with family and domestic violence leave. If the employee doesn't provide the requested evidence, they may not get paid. So it's reasonable for you to ask for evidence, and that evidence could be a stat dec, documents issued by the police, documents issued by a court, family violence support services documents, or employees have to take reasonable steps to keep the information about the employee's situation confidential. So one of the key things here is when you're processing it through your payroll, it shouldn't be recorded on the pay slip as family and domestic violence leave. It should be ordinary time. And there's a reason for that, because obviously if somebody's in a family and domestic violence situation and their partner has access to their pay slips and they see that, that's the rationale behind that. So you need to be able to record it internally as opposed to on the pay slips. And it can also be in association. So I had a situation where it was the brother of his sister was in a family domestic violence situation. He needed to support her in court. He was entitled to take that leave. So in the legislation, that's where that came through. So he personally wasn't giving it, but he was supporting a family member who was going through a difficult situation. So what you need to do is review your policies, have a clear procedure how to manage the leave, in particular your payroll, as I said, and noting it shouldn't be recorded on your leave, and educate your management team on the policies and the procedures, and also your staff that they're eligible to have that leave.
So another big change that we're seeing is in relation to fixed term contracts. So recently the Australian government decided that fixed term contracts do create a sense of insecurity for employees. So a fixed term contract is a contract that has a specified term or a maximum term. So a fixed term that's specified states that the employment will be completed after a certain period of time, and the employment can't be terminated earlier than that time. Or a maximum term contract is that the contract may be terminated on notice prior to the expiry of the term on it. Basically, from the 6th of December this year, amendments that have been made to the Fair Work Act will come into effect, which include new obligations in respect to fixed term contracts. So the changes will limit the period that a fixed term contract can be, which is to 2 years. So the employer won't be able to issue fixed term contracts that extend beyond 2 years unless you meet one of the exceptions, which I'll go through in a moment. You'll also be required to provide the person with a fixed term contract information statement, and the failure to comply with these new fixed term contract terms can mean that there can be claims made against you, including general protections claims. So it's quite an important change that's coming through. So the new changes will apply to an employee that enters into a contract of employment with an employee, but it can also include existing ones. So there will be an obligation to review existing fixed term contracts with contracts that have a termination date and they're not casual employees. The contract won't be able to be more than 2 years unless you meet one of the exceptions. If the contract is renewable for a period greater than the 2 years or can be extended more than once, then this is where these fixed term contracts need to be reviewed. So the exceptions to the rule are that if the employee is going to be on a fixed term contract longer than 2 years, they can either be a trainee agreement or an apprenticeship or traineeship. So there's obviously a lot of businesses that hire apprentices and trainees, so they're one of the exceptions. However, it'll be an obligation on the employer to prove that that is how they've actually been engaged. So you need to ensure that you fit one of those exceptions if applying. If the performance is of an identifiable or distinct task, which involves the use of a specialist skill for a specific period, that's another exception. If the employee is earning more than the high income threshold, which is currently $167,500, if you're undertaking temporary work by replacing an employee on long leave, if you're performing a government position for a limited time under a company's governing rules, If you're employed to undertake essential work during a peak demand period or employed under an applicable modern award, then these are some of the exemptions that apply. So it's really important to ensure that anybody that is over that 2-year fixed term period from the 6th of December does meet one of those exceptions. In terms of issuing the fixed term contract information statement, so that's going to be something that all employees on fixed term contracts are required to be provided. After the employment has commenced, the employers will need to provide that document as soon as reasonably possible. The document is not currently drafted as yet, and the Fair Work is finalising that document, and then it will be available to be provided. And the Fair Work Ombudsman said that it will set out the details of the fixed term contract, the limitations and the exceptions, and any dispute resolution process in the event that you don't comply with the obligations of the 2 years. So basically what this means for you is that employees will be required to amend any fixed term contracts to the period of the 2 years if you don't meet the exceptions, and that you will need to give all people on fixed term contracts this information statement and reconsider every previous contract to count them towards the 2-year limit. For any of the breaches of this change, then you will be liable for monetary penalties. So it is really important to ensure that you're complying with it and taking active steps to ensure that you're enforcing this fixed term changes, because you can be held accountable for those. So the recommendation is that you review any future and current fixed term contracts to ensure they're complying with the rules. Obviously, exercising diligence when you are hiring people on fixed term contracts to ensure that they're either the 2-year terms or they do fix one of the exemptions, and having a discussion with your HR team and your business partners regarding future changes and staff hired under fixed terms. So.
Okay, well, that's a lot of information so far. So, all right, so I thought I would talk about flexible work arrangements. We're seeing a transition, just knowing the difference between a flexible work arrangement and work from home is slightly different. So flexible work arrangement under the National Employment Standards is where an employee would be eligible for a flexible arrangement. So I've set out in the slide what is a request that might be warranted. So someone who's pregnant, are a parent or have a responsibility for care, are a carer, have a disability, are 55 or over, are experiencing family and domestic violence, or are caring or supporting an immediate family or household member. So one of the key things is in relation to business is, well, what is reasonable business grounds to deny it? Because sometimes it doesn't work for the business necessarily, but might work for the individual. So examples of those sorts of changes can be changes in hours, so modifying and a reduction in hours, or changes to start and finish times, changes in the pattern of work, splitting shifts or job sharing, changes in the location. I'm seeing that a fair bit. People don't want to travel. And I think this COVID has caused us some fun things. So in relation to location, I think particularly when we talk about, what is the expectation when the person takes on the role, it's really important to have those employment contracts. They seem like a tedious thing at the time, but without having them, it really sets out what the expectation is, and you're moving away from that expectation and what the inherent requirement of the role is. Then you've got to look at, well, what is the flexible arrangement? What am I willing to do? Does it work for the business? One of the key things that I always recommend to employers is, if they do fit the criteria, what does it look like, and can we do it on a trial basis to see whether or not it fits within the reasonable ability to keep running your business. It doesn't always work, and you do have the ability to say no. However, by saying no and not actually giving consideration to it can be a breach. So full-time and part-time employees are entitled to make a request if they've completed at least 12 months of continuous service and their employer immediately before making the request. And casual employees are entitled to make the request as well. They've been working for the same employer regularly and systematically for at least 12 months, and there is a reasonable expectation of continuing employment by the employer on a regular and systematic basis. So there's a few things that need to happen, and you need to make sure you follow these, because if you don't have records of it, you can find yourself in a bit of hot water. So an employee must, in writing, request the change. The employer is to respond within 21 days in writing, whether they approve or deny the request, or set out an alternative. And that's what I was saying about, well, okay, you might not be able to do exactly what the request is, but what is an alternative for the business? Only if they meet that list of criteria is this available. The other thing I will note that is just with flexible work arrangements, even if they don't meet the criteria, if they are an employee that you want to hold on to, then it's really advised to have those conversations around, is it a short period thing? Are they caring for someone? Are they having problems with certain personal things in their life? It might not be for a long period of time. It could just be for a set period and you just review it. But make sure all of that is in writing. So the employer must discuss the request with the employee, and you must genuinely try and reach an agreement. And you must consider consequences for the employee if refused. So if it is a situation where they're caring for somebody and you're refusing it, what happens in that situation for that person that they're supposed to be caring for? That's one of the reasonable considerations that will be taken into account. So what are the reasonable grounds to refuse? Well, the cost and impact on your business. The capacity, maybe it is that you can't have that person doing those hours because you work on sites and all the team go together at the same time, and it's logistically very difficult to, if you're travelling to North Sydney or something, to have to implement that. If it's practical, if it's inefficiently, or what would be the impact. So if there's a dispute with the employer and you can't come to some kind of agreement, the employee can make an application to the Fair Work Commission. So if it's been refused, or if you haven't responded in the 21 days, the ones that I'm seeing at the moment isn't that the employer is refusing the request, they're just not responding. So they're either forgotten, or they're like, oh, get back to it, we're all busy. Just make sure, best way to make sure that you're doing that is if a request comes in, diarise that you're meeting the deadline of the 21 days, have those conversations. Because what's happening is it's getting into the Fair Work Commission, and then the employer's like, oh no, I don't have an issue with it. It's just wasting everybody's time, money and effort. And it also affects the relationship that you have with that employee if the employee is coming to you and following the process. So if it does go through the Fair Work, the matter can be dealt with similar to the unfair dismissal space, is by way of conciliation, mediation and sometimes arbitration. Generally, I see more so than not in the Fair Work Commission a lot of conciliation, a lot of resolution. But there are times when, it just can't get to that point. So the Fair Work can actually take it to arbitration, and they have the power to make orders in relation to the request. So I always say that it is better to control the environment than let somebody else control it for you. So we've got to be able to work out what would work and would not. Some of the things that I'm seeing coming through relate to they're not actually eligible for it. So there's an argument about eligibility, not about what the request was. And some of the other things is it simply doesn't work for the business because of logistical reasons. So it's an interesting space. Most of them actually resolve. So it's good to try and be on the front foot, deal with it, because those sorts of things do take time out of your business, do take time out of your day. You've got to appear normally by a telephone, and it's all about trying to come to a resolution. Okay.
So just when we thought there was enough changes already, another change that's come up is in relation to casual employees. So your casual employees, there's no definition of what they are under the Fair Work Act, but generally we define them as employees that are required on demand. So they have no guaranteed hours of work and work irregular hours with no certainty of ongoing work. The Fair Work Amendment Act made changes to the national employment standards relating to casual employees. One of these big changes was that casual employees now have access to a pathway to becoming a permanent employee. So what that means is that the proposed changes introduce an employee choice process where a casual employee can notify an employer that they no longer feel that they meet the definition of a casual employee, particularly when they've been working in a business for over 12 months on regular systematic hours. What that means is that an employee then has to consider that, that position that they've provided, that they no longer qualify to be casual and wish to be made permanent, and an employer has to consider that and provide an explanation if they don't agree or deny it. With that pathway means that the government's basically trying to address the loophole that people were using casual employees as a way to get around some of the, the benefits that need to be paid to permanent staff and things like that without giving that job security and, having to pay those benefits. And so basically this change is taking that ability away after somebody has been with the company for 12 months. Basically it's something to look out for, but any casual employees now that have been employed for more than 12 months can approach you to seek that they be made permanent, and it is something that you have to consider. And if you don't consider it, or if you don't have valid reason to deny it, then these disputes can arise and they will be addressed by the Fair Work Commission, and you can be held accountable for those misrepresentations. So that's one really important change. Other things that casual employees now under the National Employment Standard are entitled to are 2 days of unpaid carers leave per occasion, 2 days compassionate leave per occasion, paid family and domestic violence leave, which Belinda spoke to us about earlier, unpaid community service leave. Casual employees are also allowed to request flexible working arrangements and take unpaid parental leave if they have been a casual employee on a regular and systematic basis for at least 12 months. And it is also reasonably expected that that casual employee will continue to be employed on a regular systematic basis after that leave as well. So they're really important changes to keep an eye on. Separate to this, we're seeing other changes that are coming into effect in other states. So at present in New South Wales, casual employees aren't entitled to receive paid sick or annual leave. That's outside of the current national employment standards. But whilst that's a position in New South Wales, there's actually been some recent changes in Victoria, and they're leading the path to change for casual employees in this regard. So they've actually just introduced in Victoria a sick pay for Victorian casual employees, which means that casual and self-employed workers in Victoria now can get financial safety to take time off for paid sick and annual leave. And basically that's through a Victorian pay guarantee where eligible workers are signing up for, it's like a government scheme. And if they work, regular and systematic as casual employees, they can access up to 38 hours a year of sick leave and carers pay. So it's an Australian first, and it's fully funded by the government, and it's at no cost to the business at this stage, but we're not sure how that's going to change. There's no word on whether it's going to be introduced in other states, but it's definitely a watch this space scenario to see whether it will come into New South Wales as well. So there are some big changes there with casual employees as well. So again, recommendations that you do review your employment contracts and procedures regarding your casual employees, particularly those that have been with you for longer than 12 months, and consider how you move forward with those employees, noting the obligation to now consider that and have valid reason. If you don't want to make them permanent, then there could be some problems for you later down the track. So,
Oops. Okay, work from home. We love this word. So there obviously has been a huge transition after COVID for work from home options. Some of the things I'm actually seeing in relation to, which I'll talk about a little bit later, are workers' compensation claims coming out of work from home because you're no longer controlling the environment. So if you're not controlling the environment, then how are you supposed to manage your safety obligations? So I thought I would just talk a little bit about work from home and the things that you need to look at. So do I have a set up expectation, and how will that be measured? So depending upon your business and how that works, if you're working from home, how many hours minimum, what type of workload does that look like? How is that going to work? Setting out that expectation is really important because I know when I work from home, I put a load of washing on and do a crock pot and do whatever, but I still always make sure that I meet my minimum KPIs and my requirements, even as an owner of a business. So it's just having that mindset of what the expectation is and what it looks like. If they are going to be picking up children and dropping them off, or what does that look like, and monitoring what the actual expectation is. There's one of the things I've noticed is that there's an increase in people working from home, but they're not answering their phones. So if people are working from home and you've got a business and the main leads are coming through that business and that person's not answering their phone, I suggest you audit that and call that number, your own business number, and see whether or not people are actually picking up the phone. Because if they were in the office, then no doubt in my mind, unless they're on the phone or away from their desk, they would pick that up every single time. We are seeing a rise in that, which is one of the frustrations of employers and small business, because new leads and jobs coming through is revenue, and you need that to continue to run your business. So what policies do you have in relation to work from home? They're things you need to think about. If someone comes to you and says, look, I want to work from home, you should always think about what's best for the business. Will it work? Will it not work? And then just offer a trial period. Don't lock yourself into a situation. Offer a trial period that if it doesn't work for the business, then you can revert back to the original contract. Some people work really well from home. I know I get a lot done from home because I don't have constant distractions of people coming in my office and all of that. But you do need to be mindful of the impact on mentoring others within the business. Also, culture within your business, because if nobody's in the office, then it's a pretty isolated, lonely space to be. So you need to be really mindful of those sorts of things. Look at the ergonomics of it. So if you've got people working at home, are they working on their couch all day with a laptop? Not ideal. In bed? Got one of those. So look at, okay, they must have a proper setup at home. Is it a private space? What does it look like? Don't let things slide. If they're not holding up their end of the flexible arrangement, it is a two-way agreement, then you need to have a discussion with them straight away. If you don't pull it up, then you'll end up with a very frustrated situation. And sometimes people just don't realise that they're doing it. They just, but I'm getting the work done. Yes, but these are all the things that we need you to do in work hours. There's no point you being available on the phone at 10 p.m. when nobody's calling if business hours are 9 to 5. So it's just really thinking about those sorts of things. Look at the culture and the effects on the business holistically, but also look at the cost savings as well. So one of the things a business raised with me recently was the toilet paper had gone down because there wasn't as many people in the business. Coffee had gone down, didn't need to. And so just be careful about that, because if you're still ordering the same level and there's no one in the office, think of the cost savings in relation to that. But also think about, well, if they're working from home and using, paper and resources and ink and all of that, then, they probably should be eligible to put in for that stuff. So you've got to be a little bit careful about it. So what you need to do, any of your current policies, or if you don't have one, create one. Look at your employment contracts and what procedures you have, and be careful to check the award. So in some situations, you've got to be careful about what hours they're allowed to do. So we've done some negotiations recently for an employee about changing their hours to be flexible, work from home, different things. And I wanted to check the award to make sure I wasn't breaching any of the award requirements, because as you know, different awards, different things. Implement new policy. It's a good way to start the discussions if you're moving towards work from home, new procedures, and audit and maintain a level of expectation. Remembering that also the way that you can definitely damage your culture is if people perceive that people are getting an advantage over someone else. Now, some people's jobs, for instance, like reception, ideally can't be done from home if you've got people walking in the business, whereas the person in the back office probably could work from home if they really wanted to. There may be a perception by that receptionist why I can't work from home. It's just having those conversations, even though it's very evident as to why. People tend to go, why do they get something that I don't have? So just making sure having that they can do it because of the requirements of the business for this. Unfortunately, you can't because we have clients coming in or there's meetings or whatever that looks like. So being really open about having the conversations is really important if you don't want to affect your culture. Okie dokie. Oh yes, workers' compensation, bullying, harassment. We are seeing an absolute influx of psychological injury claims. And it was reported in October 22, they haven't actually released the new figures yet from CIRA, which is the State Insurance Regulatory Authority, that 11% of claims are psychological. It was 6% previously. And if you look at the numbers, Safe Work reports 7,200 Australians are compensated for work-related mental health, made up of 21% of work pressure, 20% of bullying and harassment, and 10% exposure to workplace or occupational violence. That number has grown significantly, particularly in relation to mental health. And I am seeing an increase in the bullying and harassment claims that are coming through. That to me means that there's either a lack of understanding of what bullying and harassment actually means, so education is a key factor. There is a lack of policy or communication within businesses about what the expectation is, or that I think now we do work in a fairly high-paced environment. So when I first came into law, we had to send a fax and wait 14 days to get a response, whereas now it's like 14 seconds, maybe 3. And so that pressure now of work pressure constantly being available for everybody is causing a lot of claims or people to perceive the work pressure. So home life pressures, people now is normally a 2-income family, there's no parent at home, there's a lot of outside pressures going on. Financial pressures, obviously, at the moment, given the cost of fuel, cost of living, cost of all these sorts of things. Unfortunately, I don't see that changing. And at the moment, as things continue, it's going to be a hard sort of 6 to 8 months in terms of cost of living, maybe more, depending upon what the Labor government do. But the problem is that all in combination with your work pressure is just a recipe. So just being really aware of what's going on with your team, what's happening, providing that training and structure, routine, that sort of thing is really important. The psychological injury provisions provide that it must be, it can be a frank injury, for example, an injury suffered as a result of being involved in or witnessing a traumatic event, such as the death of a colleague, and can also be a disease injury. So as a result of a period of time, because bullying doesn't normally happen on this day, one day, it normally happens over a period of time. So it's the nature and conditions of that employment more so than, welcome, sit down. Okay. Welcome to take a seat. It's fine. And so we can have an acceleration, exacerbation, or deterioration. So what you need to be mindful of, and it is really hard, I'm going to be honest about this, is most people suffer mental health in their lifetime, whether it's personal reasons, grief, whatever it may be. There's no one that really doesn't. And when people are going through a challenging time, if there is something going on in the workplace that aggravates, accelerates, or deteriorates that condition and they can link it back to work, then they have a claim. So you've got to be a little bit mindful of that. Most of the time you don't even know that any staff member might have anxiety or depression or any of those things. It is becoming more and more that staff share that information now with their employers, and it's really about building a support network and having that available if it's something that you can manage. So you've got to be a little bit mindful of that. Some of the scenarios that we're seeing coming through for psychological injury is being overworked, being under-resourced, hostile work environment, being ostracised, exposure to traumatic events, or being unfairly targeted in the workplace. That on its separate side is a perception, so depending upon how they perceive things as well, being really clear about what the expectation of the role is really important versus what they can manage and what they can't manage is not, it's hard to sort of say, well, this is the role, they can't meet the role, then that's not performing the requirements of the actual role that they've taken on. That's not a matter of being overworked. So you've just got to be able to differentiate. Having those conversations really early is important. Okay, so reasonable actions of the employer pursuant to Section 11A of the Workers' Compensation Act. Belinda would see this a lot because in HR, if you are disciplining somebody in relation to performance or disciplining someone in relation to something that's happened in the workplace, that is not a reason for, if the employee has been investigated for the person to go on to workers' compensation. However, it happens all the time. So you pull it, you say we're going to have here's a show cause letter, or we're going to have a meeting, we want to talk about what's going on. The next day you get a workers' comp certificate. It is concerning to me that GPs are doing that, but unfortunately I think that GPs are under-resourced and don't actually understand what a workers' compensation claim is. The person presents with stress and they just put them on workers' comp. What then happens is that claim form and certificate goes off to the insurer, and you can actually challenge it. So we do submissions in relation to businesses to say, well, this person's only putting in for workers' comp because we're doing a disciplinary process with them, or we're doing a performance improvement plan with them, blah, blah, blah. Sometimes we get up on those, sometimes we don't. I am seeing at the moment the insurers, they were going through a stage where they were just approving everything. I am seeing on the other side now where they're starting to question, get statements, do investigations. The problem is depending on who the insurer is the delay, because they have to meet a criteria to either accept or deny the claim within a period of time. And if they can't do that, they'll either provisionally accept it while they investigate it, which means you're paying, or they will they'll do a reasonable excuse, which means they don't have the information in order to decide it. So there's a couple of things that can happen. In relation to Section 11A, it's where the employer would say that it's wholly or predominantly caused by a reasonable action taken by the employer. So that would be the disciplinary process or the performance improvement plan. The employer bears the onus with respect to the notion of whether the actions were reasonable, which is why consultation, having documentation, meetings, it might be a series of meetings even where you're saying, okay, well, you're not performing this part of your role. Make sure it's not just a conversation. Make sure there's file notes, there's letters, there's information that you can attach to the application should you get a workers' compensation claim. The test of reasonableness remains objective. So objective means a reasonable person test. So it's not an individual test, it's a reasonable person. Based on the facts of a particular case, and the task of the decision maker includes consideration of the actions taken in the context of causing the injury. So the key things here is to keep notes in letters in relation to any disciplinary process and engage HR early in the process. Don't wait until it's blown up. You need to make sure you're following the criteria, not only to try and stay out of workers' compensation, but also to stay out of the Fair Work Commission. I put in the slides just for so that people know what the definition of an injury is. So a disease injury, which is what mental health psychological is contracted by a worker in the course of employment, but only if the employment was the main contributing factor to the disease. Main contributing factor is the key. It can't be just a factor, it has to be main contributing factor. So for instance, I might look at someone's clinical notes and see that their dog died, they had stress with their children, they had this, they had that, and then they mention, work's a bit difficult. So we would then, depending upon whether I'm acting for the employer or the employee, go, okay, well, is it the main factor? When there's the other factors that could also be playing into whether psychological injury is mainly related to work, because they've got to prove that test. There's a few other things in relation to, as I said, if they've got a pre-existing, could be an aggravation, acceleration in the course of the employment, but the test is still main contributing factor. So if you've got an employee that is suffering from severe anxiety and they had that before they started, or they gained it, due to personal circumstances, not work ones, and work accelerates or exacerbates it, they have to prove that it is the main contributing factor. Work is the main contributing factor. Can't just be a factor. There's some cases that I'm constantly in review of. This one's in the PIC. Just take out some key points in relation to employers take their employees as they find them. So it doesn't matter whether you knew or didn't know, you accept them as they are. It's called the eggshell principle. Must be a perception of the real events during the course of the employment. So it's a perception of how the person receives it, but it must be a real perception. So if they're having episodes of psychosis or fabrication in their mind of what actually happened, and there's witnesses and things like that, that won't necessarily be taken into consideration. The worker's perception about whether the events created are offensive and hostile. The events must be real rather than imaginatory. You've got to be, mindful of psychological injury and the impacts that can cause to the state of mind of somebody. There's no requirement that the worker's perception must pass some qualitative tests based on an objective test, and it's not necessary for a worker's reaction to be rational, reasonable, or proportionate. It's still necessary to satisfy that the psychological effect goes beyond a mere emotional response, and it remains necessary to establish a diagnosable psychiatric condition in order to satisfy the definition. So they actually have to be diagnosed with a psychological injury under the Act. It can't just be that it's they're upset. That's not going to cut it. So what you need to do, review your policies, make sure you have clear expectations in your business, have procedures how you're going to manage bullying and harassment. That also goes back to what Belinda was talking about in terms of sexual harassment as well. Sexual harassment used to fall into this category, so psychological injury cause, it still does. The key here, I think, is education and training, understanding what bullying and harassment is and is not. Because I'm seeing a lot of people coming through where they're claiming that they were bullied or harassed, and it's just not. It's the person looked at me. Like it's getting a little bit out of control. So I think understanding what bullying and harassment is rather than not understanding is really important. I thought I'd just add in here that there's the new Stop Bully orders, which has come into place in the Fair Work Commission. I haven't had any of them yet, but I have had a client call me that they have put one in. I haven't yet seen what the outcome of that is, so they can do that directly online. It's a Stop Bullying order. The worker can apply directly to the Fair Work Commission. The employer has to respond within 7 days, and then it goes to a conciliation arbitration process to discuss what is the bullying behaviour, and an order can be made by the Fair Work Commission to tell you as a business to make sure that that stops. I haven't seen any of them yet come through as in how that logistically works in a practical sense, but I have been watching the Fair Work and there's a few in there. So it'll be interesting to see what happens, what orders get made. I suspect it will be very much like the Fair Work unfair dismissals, where they'll probably resolve at conciliation, because no business will actually want a public stop bully order that you can search on the Fair Work Commission site. So I suspect that you won't want that reputation. So a lot of people will put in place, it's not a compensation space, it's a how will you stop the bullying, how will you stop what's happening to me from happening. Some people who have multiple locations might be able to move the person. You'd also have to go into investigation of the scenario. Is there a bullying situation? They're all the things that you would respond with, that you investigated it, that you didn't identify any bullying behaviour, blah, blah, blah. you would present that back to the Fair Work Commission. The Fair Work Commission would then say, okay, well, I've got both sides here. Can we try and conciliate something? If not, then they can actually make an order, whether it be the matter is dismissed or whether they actually make a stop bully order. I haven't seen them yet, but I'm watching that space. That brings us to the end. So hopefully you got some information. Is there any questions for any of us? Oh, yes.
I run a very small business, so I've got about 3 people in the office.
Mm-hmm.
There's two other ladies that work with me. One, the problem I have in being the employer, I have 2 staff. One lady she's a little bit big,
Mm-hmm.
and then the other lady, she's more like a model.
Mm-hmm.
And she's constantly talking about, going to diet, going to gym, eat this and eat that. And then the other lady's,
Yeah.
and it's starting to tell me things like, I don't like the way she talks about this sort of stuff. It's really offending me.
Yeah.
One day I came in early in the morning, and the big lady sent me a text message from the other colleague, sending her a cartoon picture with a man and a big lady wearing a pink dress and a skinny lady wearing a pink dress, and the man is looking at the lady. And the message is saying they're both pink dresses. They're both the same dress.
Yeah. So that would be classed.
I don't feel like she's getting bullied.
Yeah, it'd be classed as harassment. There's 2 parts to it. It doesn't have to be sexual harassment. It can actually be classed as not just male or female, so it can be same sex. Firstly, it'd be classed as sexual harassment, and you'll get caught under that positive duty obligation, which can also be penalty. The second thing is that you potentially are exposed to a bullying and harassment case. So what you would need to do is have a meeting with that employee who's doing the conduct, and you need to immediately tell her to cease doing it. If she doesn't do that, then you will possibly terminate her employment. Yeah.
I thought it was just like a little, conflict between you and
You can try, you can. So I would, your obligation is to investigate it and work out what it is. But if there's pictures and stuff like that, you already know that it's happening. It's not a he said, she said situation. There's actual evidence of it. The other option is that you can call a mediation, so in-house mediation, where you can sit down and have the parties discuss, okay, well, what you're saying to me is offensive and these are the reasons why. It may put, however, that employee who's receiving the messages in a very stressful situation, because if she wanted to address it, she would have already addressed it with the employee. I think you'll have to have a sit-down meeting and say that behaviour is not acceptable, and I would roll out a policy across the business. And I would say that this is the expectation now, this is the policy, anyone who's not adhering to the policy, we will be having a meeting. So that's across the board, to both of them, because unfortunately in some situations it starts as a bit of friendly banter, oh that's really funny, and everyone's sending a message, and then the person starts to take it personal. And that's where it moves out of that friendly banter space. But unfortunately now, in 2023, you just can't do it. You cannot do it, and you shouldn't be doing it, because you will end up with a workers' compensation claim.
So I will talk to the staff that's been doing it.
Yeah.
And
I would talk to them.
Staff member to say that that's been sorted, or
I would say to the current staff member that you will be dealing with it, so the person that's been affected. I would then be having a meeting with the staff member, setting out what the complaints are in relation to the conduct, have that in writing so that the person can respond to it if they want to. It can start off as a sort of, this is not okay, but what I'm concerned about is that when we call those meetings, the next day that person puts in a workers' compensation claim. So you're better off to have a letter that sets out, this is what we're going to be discussing, this conduct is what has been raised. You have an opportunity, if you want to respond to that. There might be where she's got other text messages where the person is it could be more to the story than what we know. However, I mean, it's a matter of just saying, if you have that relationship with that employee, look, she finds it offensive, we can't have that happening, can you stop doing it? If she doesn't stop doing it, then you'll have to actually go further. Any comments by you?
Yeah, I agree with everything. But it's really important to establish what your code of conduct is, what your behaviour, what's acceptable behaviour, what's not acceptable behaviour, and that's your start point, and then have those discussions with the people that are doing it. And if you're seeing it and hearing it, then you need to correct it, pull that behaviour up at the time.
The hardest if you want to keep one.
Yeah, I mean,
Look, it's hard to find a good employer.
Yeah, I understand that. I think that's probably
and the person
why.
I'm coming from the trying to help perspective, but it's not your response. It's not your place to say you should go to the gym, you should be this. It's,
No.
You know what? She doesn't want it. It's not her place.
No.
It's.
So she's not saying that, she's just saying she's going to the gym and she's doing, I miss the gym last night.
She's not telling the other lady to go.
But she's saying it to the other lady that, about herself, but I'm thinking it's offensive to the other lady, it's the whole way it's an issue for her and she doesn't want to having someone constantly telling her every day.
I would just, if I would have a conversation with the employee that's doing that and just say to them, look, I need you to be mindful of how the person receives it, even if it's said without intention. Okay, so it could be just said off the cuff, not even thinking about it. But the problem with it is it's how they receive it that will put you in the hot water. So, and if it's a one-time thing, I went to the gym last night, whatever. But if it's just constant, that is a form of harassment. Yeah.
Should I tell her that can be considered harassment?
Yes, it could be considered harassment. I don't want to have any complaints by that employee. I don't want to have any, let's just stop now. And then I would has the employee that it's against raised any concerns with you directly?
Yes.
Yeah, so you need to respond to her and say, look, I've spoken to her. If anything else if anything else has comes up or is said or done, please bring it to my attention. So that she knows that she's got an avenue to go to and not just sitting there. Otherwise, she'll either resign or she'll bring a claim.
Yeah. Thank you.
That's all right. Any other questions?
Just one quickly. With the casuals being eligible for the compassionate leave and the paid domestic leave, I'm assuming that has to be in their contracts now. And do they have to be with the company for any certain time before they're eligible for those?
Yeah. So
it's it's still unpaid. They're just entitled to access those 2 days per occasion.
Okay.
Yeah. So that's what the changes are, that they're entitled. We generally draft into our casual contracts, that they're able to access up to those 2 unpaid days per occasion.
Yeah.
So it would be a good idea to update your policy, your contracts if you don't have that in there at the moment.
Yeah.
There's no requirement of how long you're with them to be entitled to that unpaid 2 days.
Yeah.
That 12-month thing comes in relation to more converting to permanent employment and things like that, and the flexible arrangement and stuff.
Yeah, sure.
Yeah.
And just one other question with the domestic violence leave. One of my girlfriends is going through this at the moment, and her workplace has actually told everybody. Like, she's spoken to her direct line of management as well as the HR. They've allowed her to have the days off, whatever she needs to take. But unfortunately, the words got out, and pretty much most of the workplace knows about her situation, which I think is disgusting. Where would the employees sit in terms of that? Like, where would she go from there?
Look, I would think that depending upon the impact of her psychologically, she could end up putting in a claim. It depends on how much it's filtrated through. There's a breach of privacy, obviously, but I suspect depending upon the situation, how it got leaked, it may have been she told someone and that person told someone else, and it may not necessarily be systemic from the top, because we do see that a lot where it's assumed that the employer has shared it, but it's actually she's told someone sitting next to her and it's spread. Look, I mean, it's not an easy one. She potentially, if she could show that the employer has caused her psychological damage because of it, she could end up with a claim. But generally, I think it's just a conversation around she won't necessarily know how it got out. There's not much she can do besides, there's just not, I would have the conversation with the employer and say, look, my situation is this. And it's hard, right? Because they're already going through enough.
Sure.
And it's hard because you have employees who, same thing with sick leave or personal leave. People start to think, oh, why are they off? What's happening? Blah, blah, blah. And it might have been something someone posted on a Facebook, you know, like a meme or something, and people just draw from that. Oh, there must be domestic violence, or must be something going on at home, because people don't realise through their communications, people just assume things. Yeah. There's not much she can do, but I would definitely, if it's bothering her to a point where she should be going and seeing her GP, having a conversation.
Yeah, for sure. Because you'd think at some level there was quite a bit of protection for the employee with something in that circumstance.
Yeah, she would have to be able to show that the employer breached privacy, which I think will be hard.
Yeah.
Because generally they've told someone. Or someone's told someone. Do you know what I mean? Like they've told someone, and even if it wasn't within the company, that person knows someone else. And particularly in our local community, tell anyone, everyone knows everything. You just got to be a little bit careful about the accusation, where it came from, without knowing the source. Yeah.
Okay.
Any other questions? No? Okay, thank you so much. Lovely to see you all.